I'm Emma Torres, 34 years old, and for 6 years I poured my soul into developing technology that would revolutionize medical diagnostics. I worked in a cramped lab, survived on vending machine dinners, and sacrificed relationships to perfect an algorithm that could detect early-stage cancers with 94% accuracy. Then Derek Callahan, the CEO's nephew with an MBA from his uncle's alma mater and exactly 0 years of biotech experience, fired me over a 15-minute Zoom call. He handed me a severance check for $3,800, 3 months of my pathetic junior researcher's salary, thinking that would be the end of it. What he didn't know, what none of them knew, was that buried in my original employment contract was a patent reversion clause I'd negotiated when I was too naive to realize most companies would never agree to such terms. That cheap severance check, the moment I cashed it, triggered a legal mechanism that would strip Meditech Solutions of the very technology currently valued at $47 million in their upcoming acquisition deal. If you've ever been dismissed by someone who inherited their position while you earned every qualification you have, stay with me. This is about what happens when arrogance meets fine print, and when the person they underestimated turns out to hold all the cards they didn't know were in play. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. I grew up in Sacramento, California, the daughter of 2 public school teachers who believed education was the great equalizer. My father taught high school chemistry, my mother middle school mathematics, and our dinner table conversations often revolved around scientific discoveries and problem-solving methodologies. While other kids watched cartoons, I was helping my dad prepare demonstrations for his classes, learning to balance chemical equations before I understood fractions. My fascination with medical technology began at 13 when my grandmother was diagnosed with ovarian cancer. By the time doctors caught it, the disease had already progressed to stage 3. I watched this vibrant woman who taught me to bake sourdough bread and identify constellations deteriorate over 18 brutal months. The oncologist explained that if they'd detected it earlier, her survival odds would have jumped from 30% to 85%. That single statistic haunted me. 85%. An entire life potentially saved by earlier detection. From that moment, I structured my entire academic path around one goal: developing better early detection methods for cancers that kill people because we find them too late. I devoured every research paper I could access on diagnostic imaging, biomarkers, and machine learning applications in medicine. My high school science fair project analyzing protein markers in simulated blood samples won state competitions and earned me a full scholarship to UC Berkeley. At Berkeley, I double majored in biomedical engineering and computer science, graduating summa cum laude despite working 20 hours a week at the campus library to cover living expenses my scholarship didn't touch. While my classmates enjoyed typical college experiences, parties, football games, spring break trips, I spent weekends in the engineering lab or the campus medical library, teaching myself advanced programming languages and studying oncological research that wouldn't be covered in my curriculum for another 2 years. My professors noticed my obsessive focus. Dr. Patricia Ramirez, who taught my advanced biomedical instrumentation course, pulled me aside during my junior year. "Emma, you're brilliant, but you're burning yourself out," she said with genuine concern. "There's value in balance, in experiences outside the lab." I appreciated her worry, but she didn't understand. Every day I wasn't working toward better diagnostics was a day someone's grandmother, someone's mother, someone's sister was being diagnosed too late. The urgency that drove me wasn't about grades or accolades. It was about the 85% survival rate that my grandmother never got the chance to reach. After Berkeley, I was accepted into Stanford's graduate program in bioengineering with a focus on computational diagnostics. My thesis proposed using machine learning algorithms to analyze combinations of biomarkers that individually seemed insignificant but collectively could indicate early-stage carcinomas. The concept wasn't entirely novel. Several research teams were exploring similar territories, but my specific algorithmic approach and the particular marker combinations I identified showed unprecedented promise in initial testing. Stanford provided better resources than Berkeley, but graduate student stipends barely covered rent in Palo Alto. I lived in a converted garage with 2 roommates, ate primarily rice and beans, and wore the same 3 outfits on rotation. My younger brother Carlos, who had chosen a more conventional path in business administration, would send me grocery store gift cards with notes saying, "Please eat something green occasionally." The sacrifice felt worthwhile when my thesis research started producing remarkable results. In controlled studies using archived patient samples, collected with full ethical approval and anonymization, my algorithm detected early-stage ovarian cancer in 89% of cases where traditional screening had missed it. For pancreatic cancer, notoriously difficult to catch early, the accuracy reached 87%. These weren't just statistics. These were potential lives saved, families spared the devastation mine had endured. Dr. James Whitmore, my thesis advisor and a legend in biomedical engineering, encouraged me to pursue patent protection for my algorithmic approach before publishing. "This has genuine commercial potential, Emma," he explained during one of our weekly meetings. "The right company could develop this into a clinical tool that saves thousands of lives. But if you publish the methodology first without patent protection, anyone can use it and you'll have no control over how it's developed or deployed." The patent process was bewildering and expensive. I found an intellectual property attorney willing to work on a partial contingency basis, believing in the technology's potential. Together, we filed a provisional patent application, buying me a year to find either funding to pursue full patent protection or a company willing to license the technology and cover the costs. That's when I met Richard Callahan at a biotech networking conference in San Francisco. His company, Meditech Solutions, specialized in developing diagnostic tools for clinical use. They had successfully brought 3 products to market and had relationships with major hospital networks across the country. Richard's keynote speech emphasized Meditech's commitment to transformative diagnostic innovation and partnering with brilliant researchers to bring life-saving technology to patients. After his speech, I approached him with a carefully prepared 2-minute summary of my research. I had refined this pitch through dozens of awkward networking attempts, learning to communicate complex algorithmic processes in terms that highlighted patient impact rather than technical specifications. Richard listened with what seemed like genuine interest, asked several insightful questions about accuracy rates and potential applications, and handed me his card. "Send me your research summary and let's schedule a proper meeting," he said. This is exactly the kind of innovation Meditech exists to develop. The meeting happened 3 weeks later at Meditech's headquarters in South San Francisco. Their office occupied 2 floors of a modern building with panoramic bay views, a stark contrast to the cramped university labs I was accustomed to. Richard introduced me to Dr. Susan Park, their chief scientific officer, and Marcus Webb, vice president of research and development. Over 2 hours, I presented my research, answered technical questions, and discussed the pathway from algorithm to clinical diagnostic tool. They were impressed. Susan, who had a background in oncological research, immediately grasped the significance of my biomarker combinations. Marcus asked detailed questions about scalability and integration with existing diagnostic workflows. Richard focused on market potential and patient impact, the business side of bringing innovation to healthcare. "We'd like to offer you a position as senior research scientist," Richard said as the meeting concluded. "You'd lead the team developing this technology for clinical application, with full support and resources to move from research to FDA-approved diagnostic tool." The offer felt like validation of every sacrifice I'd made. A real salary, $78,000 annually, which seemed like wealth compared to my graduate stipend. A dedicated lab with proper equipment and support staff. The opportunity to see my grandmother's legacy transform from academic research into actual patient care. But there was the complication of my patent application. I explained to Richard that I'd filed provisional protection and would need any employment agreement to address intellectual property rights clearly. This was the moment that would define everything that followed, though I didn't recognize its significance at the time. "Absolutely understandable," Richard assured me. "Many of our researchers come to us with preliminary patent work. Let's have our legal team draft an agreement that fairly compensates you for bringing this technology to Meditech while giving us the ability to develop and commercialize it." The employment contract arrived a week later. It was dense with legalese, 37 pages of clauses and subclauses that made my eyes glaze over. I couldn't afford an attorney to review it. The patent lawyer had already stretched my finances beyond comfortable limits. I did what most people do in that situation. I read it myself, tried to understand the critical sections, and trusted that a reputable company wouldn't deliberately deceive a new researcher. Most of the contract was standard employment language about responsibilities, benefits, and confidentiality. The intellectual property section confirmed that any work I developed using Meditech resources would belong to the company, which seemed fair. But there was a specific clause about pre-existing intellectual property that I'd brought to the company. It stated that I would assign my patent rights to Meditech in exchange for 2% equity in any commercial products derived from my algorithm, plus milestone bonuses tied to FDA approval and market launch. 2% sounded modest, but Marcus had explained that if the diagnostic tool achieved even a fraction of its potential market penetration, that equity could be worth substantial money. More importantly, I'd be leading the development team, guiding my research toward real-world application. The bonuses included $25,000 upon FDA approval and another $50,000 when the product launched commercially. What I nearly missed, buried in subsection 14.7 of the Intellectual Property Clause, was a reversion provision. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel, it means a lot to us. Now back to the story. It stated that if my employment was terminated by Meditech without cause before the product reached FDA approval, and if the severance payment was below a certain threshold, calculated as 6 months of salary plus benefits, all patent rights would revert to me. The company would retain a non-exclusive license to continue development, but I would regain primary ownership and could license the technology to other entities. I remember reading that clause 3 times, puzzled by its inclusion. Why would a company agree to potentially lose patent rights they'd acquired? I called the HR representative who'd sent the contract, a cheerful woman named Diane who'd been my point of contact through the hiring process. "Oh, that's a standard protection clause," Diane explained. "It's actually there to protect both parties. If we terminate someone without cause early in a project, before they've really benefited from bonuses and equity, they're not left with nothing to show for the IP they brought in. But the threshold is set high enough that it rarely applies. We'd have to let you go and give you less than 6 months of severance, which wouldn't happen for a senior researcher." Her explanation made sense. It seemed like a gesture of good faith, acknowledging that if they brought me in specifically for my patent and then terminated me before I could realize any benefit from it, I shouldn't walk away empty-handed while they profited from my years of research. I signed the contract, started at Meditech Solutions 3 weeks later, and entered what I believed would be the most fulfilling phase of my career. The first 18 months proved that belief accurate. I assembled a research team of 7 talented scientists and programmers, each bringing specialized expertise that complemented my own. We had access to resources I'd only dreamed of in academia, state-of-the-art computing power for running complex simulations, partnerships with hospitals providing properly consented patient data, and collaboration with clinical oncologists who helped refine our approach for real-world diagnostic scenarios. The algorithm evolved significantly during this period. My original thesis version had been proof of concept, demonstrating that the approach worked in controlled conditions with archived samples. Transforming it into a reliable clinical tool required addressing dozens of variables I hadn't encountered in academic research. Different patient populations, variations in sample collection and handling, integration with existing laboratory workflows, standardization for consistency across different testing facilities. Each challenge demanded creative problem-solving and rigorous validation. My team worked with dedication that matched my own. Jennifer Liu, a computational biologist I'd recruited from Berkeley, developed innovative methods for handling noisy data from real-world samples. Akash Patel, who had experience in clinical chemistry, designed protocols that ensured consistent sample processing. Marcus Webb provided strong support from leadership, securing funding for additional validation studies and facilitating partnerships with medical centers willing to participate in clinical trials. We published preliminary findings in the Journal of Clinical Oncology, carefully protecting the proprietary algorithmic details while sharing enough to contribute to the scientific community. The paper generated significant interest, with several major cancer centers reaching out about participating in expanded trials. I presented at conferences, fielded questions from respected researchers, and experienced the profound satisfaction of seeing years of solitary work validated by peers I admired. Richard Callahan seemed genuinely pleased with our progress. He'd check in quarterly, always enthusiastic about our latest results, always emphasizing how Meditech was proud to support transformative research. "You're going to save lives, Emma," he'd say, and I believed him. The company's mission aligned perfectly with my own. But there were subtle signs of changes in the company's priorities that I didn't fully recognize at the time. Meditech had traditionally focused on developing innovative diagnostic tools, even when market potential was modest. They had products for rare diseases that generated minimal profit but filled genuine clinical needs. This mission-driven approach was part of what had attracted me to the company. During my second year, I noticed shifts in leadership discussions and company messaging. There was increased emphasis on shareholder value and market positioning. Richard hired several executives with backgrounds in pharmaceutical sales and business development rather than scientific research. Board meetings, which I occasionally attended to present research updates, included more discussion of acquisition potential and exit strategies. I mentioned these observations to Susan Park during one of our regular mentoring coffees. Susan, who had been with Meditech since its early days, acknowledged the shifts with a resigned expression. "Companies evolve, Emma," she said. "Richard's under pressure from investors to show returns. As long as we can continue doing good science and getting products to patients, we adapt to the business realities." Her pragmatism made sense. I was a scientist, not a business expert. If shifting some corporate priorities allowed Meditech to continue funding research that saved lives, that seemed like acceptable compromise. I returned my focus to the work, trusting that the adults in charge understood things I didn't. The algorithm reached a critical milestone in month 22. Completion of our Phase 2 clinical trials. We'd tested the diagnostic tool on 847 patients across 6 medical centers, comparing our results against both traditional screening methods and eventual biopsy confirmations. The data was extraordinary. For ovarian cancer, we achieved 91% detection accuracy in early stages, compared to 45% for standard CA-125 blood tests. For pancreatic cancer, accuracy reached 88% in stages 1 and 2, dramatically better than current diagnostic approaches that typically caught these cancers only after they'd progressed significantly. These weren't incremental improvements. This was a fundamental advancement in early cancer detection for malignancies that killed people specifically because we found them too late. I thought about my grandmother constantly during the data analysis phase. She would have been part of that 91% detected early, part of the 85% survival rate instead of the 30% she'd faced. The research team celebrated our Phase 2 results with quiet satisfaction. We knew the FDA approval process still lay ahead, easily another 18 months of regulatory hurdles and additional validation studies. But we'd proven the core technology worked in real clinical settings. The path forward was clear. Richard Callahan scheduled an all-hands company meeting for the following week, which seemed appropriate for sharing such significant results with the broader organization. I prepared a presentation summarizing our findings in language accessible to non-scientists, emphasizing the patient impact and the pathway to FDA submission. The morning of the all-hands meeting, I arrived early to test the presentation equipment and review my notes. Marcus Webb intercepted me in the hallway outside the auditorium, his expression unusually serious. "Emma, there's been a change of plans for the presentation," he said carefully. "Richard wants to handle the announcement himself. He'll reference your research, but he's going to frame it within some broader company news." I felt a flutter of unease but dismissed it as normal corporate communication strategy. Richard was the CEO, naturally he'd want to present major developments in the context of overall company direction. I took a seat in the audience as employees filed in, noticing an unusual number of unfamiliar faces in business attire scattered among the Meditech staff. Richard opened the meeting with his characteristic charisma, thanking everyone for their dedication and highlighting Meditech's growth over the past year. Then he pivoted to the announcement. "Today, I'm thrilled to share that Meditech Solutions has entered into a definitive agreement to be acquired by Titan Healthcare Corporation," he announced. "This partnership will provide resources and market access that allow us to bring our innovative diagnostics to patients faster and more effectively than we could alone." The auditorium erupted in surprised murmurs. An acquisition hadn't been mentioned in any internal communications. Richard continued over the noise, explaining that Titan Healthcare was a major player in the diagnostics industry with established relationships with hospital networks worldwide. The acquisition valued Meditech at $127 million, representing a significant return for investors and creating opportunities for employees within a larger organization. Our cancer detection platform, led by Dr. Emma Torres and her exceptional team, was a key factor in Titan's interest, Richard continued, gesturing toward where I sat. Their Phase 2 results demonstrate technology that could reshape early cancer diagnosis, and Titan has the infrastructure to bring this to market rapidly. Polite applause followed, but I barely heard it. My mind was processing implications. An acquisition meant new ownership, new priorities, potential reorganization. What happened to equity agreements when companies were acquired? What happened to researchers' roles within a larger corporate structure? After the meeting, I cornered Marcus in his office. What does this mean for the research team and the development timeline? I asked directly. We're at a critical juncture with FDA preparation. Marcus leaned back in his chair, looking uncomfortable. Honestly, Emma, a lot depends on how Titan wants to structure the integration, he admitted. They've indicated strong interest in the cancer detection platform specifically. That's positive. But there will be reorganization, duplicate roles being consolidated, priorities being re-evaluated. My employment contract includes equity in products derived from my algorithm, I said. Does that equity convert in the acquisition? That's being handled by legal and finance teams, Marcus replied. I don't have specific answers yet, but I've been assured that existing commitments will be honored appropriately. The word appropriately carried concerning ambiguity, but I had little leverage to demand specificity. Over the following weeks, the acquisition process unfolded with bureaucratic inevitability. Teams of lawyers and accountants swarmed the offices, conducting due diligence and preparing integration plans. Titan Healthcare representatives visited regularly, observing operations and interviewing key personnel. I met with Titan's Vice President of Research, Dr. Harold Chen, who reviewed our cancer detection platform with clear expertise and asked insightful questions about our validation methodology. Impressive work, Dr. Torres, he said after a 3-hour technical discussion. This technology has significant potential within Titan's diagnostic portfolio. His assessment seemed positive, and I allowed myself cautious optimism that perhaps the acquisition would simply mean better resources for continuing the research. Then Derek Callahan entered the picture, and everything I'd built began to crumble. Derek Callahan was Richard's nephew, 28 years old with an MBA from Georgetown and exactly 3 years of experience in management consulting before his uncle hired him as Director of Strategic Initiatives at Meditech. I'd seen him occasionally at company events, where he'd make brief appearances, shake hands with senior staff, and leave early for what he described as important meetings. He had the polished confidence of someone who'd never experienced meaningful professional setbacks, paired with the casual arrogance that comes from knowing family connections will catch you if you fall. When Titan Healthcare completed the acquisition, Richard Callahan announced his retirement with a generous exit package that valued his shares at approximately $23 million. Susan Park, our chief scientific officer, also departed with a substantial payout, accepting a research position at UCSF. Marcus Webb stayed on initially, but it quickly became apparent that Titan had their own research leadership structure and his role was redundant. He left 3 months post-acquisition with a severance package and a polite recommendation letter. What shocked everyone was Derek Callahan's appointment as interim vice president of research operations for the Meditech division within Titan Healthcare. He had no scientific background, no research experience, and no apparent qualifications beyond his family connection to the previous CEO and whatever political maneuvering he'd accomplished during the transition period. The appointment was announced via email on a Friday afternoon, the corporate equivalent of burying news you'd rather people not examine too closely. My first direct interaction with Derek in his new role came the following Monday when he scheduled individual meetings with all department heads. I prepared a comprehensive briefing on our cancer detection platform status, current development timeline, and requirements for moving toward FDA submission. When I entered his office, formerly Marcus's space but now redecorated with expensive modern furniture that looked lifted from a design magazine, Derek was scrolling through his phone and barely glanced up. "Dr. Torres, have a seat," he said, still focused on his screen. This shouldn't take long. I sat, my prepared materials in a folder on my lap, and waited. He finally set his phone down and gave me his attention with the expression of someone checking off a required task. "So, the cancer thing," he began. "Walk me through what the current status is and what you need from me." The casual dismissal of years of research as "the cancer thing" set my teeth on edge, but I maintained professional composure. I explained where we stood with validation studies, our readiness to begin FDA submission preparation, the partnerships we'd established with medical centers for expanded clinical trials, and the staffing and resources required for the next phase. Derek listened with an expression that suggested he was processing perhaps half of what I said. When I finished, he leaned back in his leather chair. "Right, so here's the situation from the business side," he said. "Titan acquired Meditech primarily for the cancer detection IP, you're correct about that. But their strategy isn't to continue independent development. They want to integrate the technology into their existing diagnostic platform and handle development through their centralized research facility in New Jersey." I felt my stomach tighten. "Our team here has been developing this technology for over 2 years," I said carefully. "We understand the nuances of the algorithm, the specific challenges in clinical implementation, the relationships with trial sites. Moving development to a new team would create significant delays and risks losing institutional knowledge." "I understand your concerns," Derek replied in a tone that suggested he didn't, in fact, understand or particularly care. "But Titan's decision is based on efficiency and resource optimization. They have established infrastructure for diagnostic development and FDA processes. Duplicating that infrastructure here doesn't make business sense." "What happens to my research team?" I asked directly. "That's still being determined," he said. "Some positions might transfer to New Jersey if those individuals are willing to relocate. Others will likely be transitioned out as their current projects wind down." The clinical language of corporate restructuring couldn't disguise what he was describing, dismantling everything we'd built. "And my role?" I pressed. Derek's expression shifted slightly, becoming more guarded. "Your situation is complicated because of your specific contract terms around the intellectual property," he acknowledged. "Legal is reviewing how your equity arrangements translate post-acquisition. In the interim, we're placing you on a special project focusing on documentation and knowledge transfer to ensure smooth handoff to the New Jersey team." Documentation and knowledge transfer. The professional equivalent of being sent to an empty room to organize files while the actual work continued without you. I recognized the maneuver for what it was, sidelining me while they figured out how to handle the contractual complications I represented. Over the following weeks, I watched the systematic dismantling of everything I'd built. Jennifer Liu, my computational biologist, was offered a position in New Jersey at a salary barely higher than what she currently made, requiring her to relocate across the country and leave her partner who had an established career in San Francisco. She declined and found a position at a Bay Area startup within 2 weeks. Akash Patel similarly refused relocation and began job searching. One by one, my team members either left for other opportunities or accepted the New Jersey transfers, scattering the collaborative unit we'd built. I was assigned to work on comprehensive documentation of our algorithm's development process, writing detailed technical specifications that would theoretically allow the New Jersey team to understand and continue our work. It was important work in principle, but emotionally devastating in practice. I was essentially writing the instruction manual for someone else to complete my life's work. Derek scheduled weekly check-ins that rarely lasted more than 15 minutes. He'd skim whatever documentation I'd completed, nod vaguely, and offer comments that made it clear he didn't understand the technical content. "Make sure you explain the statistical methods more clearly," he'd say about sections that were already explained at a level appropriate for biomedical researchers. "The New Jersey team needs to be able to replicate your results exactly." During one of these meetings, I raised the question that had been consuming me for weeks. "My original employment contract specified equity in commercial products derived from my algorithm," I said. "With the acquisition and the shift to New Jersey development, how is that being handled?" Derek looked uncomfortable, shuffling papers on his desk. "Legal is still working through the contract details," he replied. "These things take time when companies merge." You'll receive formal communication once everything is finalized. The contract also specified milestone bonuses for FDA approval and commercial launch, I continued. Given that I'm no longer leading the development team, am I still eligible for those? As I said, legal is reviewing everything, Derek repeated, his tone sharpening with irritation. You'll be informed when decisions are made. For now, focus on completing the knowledge transfer documentation. That's your priority. The dismissal was clear, but I couldn't let it go. With respect, this is my intellectual property that I brought to Meditech, I said, working to keep my voice level. I deserve clarity about how my contractual rights are being handled in this transition. Derek's expression hardened. Dr. Torres, I understand you're frustrated about organizational changes, he said coldly. But you're an employee of this company, now owned by Titan Healthcare. Your job is to do the work you're assigned. The legal details will be addressed through appropriate channels. I left that meeting shaking with anger and fear. The power dynamics were brutally clear. Derek, protected by family connections and corporate position, could simply ignore my questions while I had no leverage to demand answers. I consulted the employment contract I'd signed 3 years earlier, reading through the intellectual property clauses with new urgency and growing dread. The contract specified that my equity and bonuses were tied to commercial products derived from my algorithm. But it didn't clearly define what happened if the company developing those products was acquired, or if I was removed from the development team before product launch. These ambiguities, which had seemed like minor technicalities when I signed the agreement, now loomed as potential mechanisms for Titan to avoid honoring the spirit of our agreement while technically complying with its letter. I finally sought legal advice, using a chunk of my savings to consult with an employment attorney who specialized in intellectual property disputes. Patricia Ng listened to my situation, reviewed my contract, and delivered an assessment that was both validating and discouraging. You have legitimate claims here, Patricia explained. The contract clearly provides for equity and bonuses. However, actually enforcing those claims against a large corporation like Titan Healthcare would require litigation that could take years and cost more than you'd likely recover, especially since the equity percentages are relatively small and the product hasn't launched yet. So they can just ignore the contract? I asked, frustration evident in my voice. Not exactly, Patricia clarified. They have to offer you something. But they can structure their offer in ways that minimize their obligation while making litigation impractical for you to pursue. For example, they might offer you a small cash settlement in exchange for releasing all claims. The settlement would probably be less than you're theoretically owed, but fighting it would cost more in legal fees than you'd gain. The cynical calculation was infuriating but undeniable. Titan had resources and legal teams on retainer. I had savings that would last maybe 6 months if I stopped earning a salary. What about the patent reversion clause? I asked, explaining the provision I'd almost overlooked when signing the contract. Patricia's expression shifted to interest. She read that section carefully, then cross-referenced it with other contract clauses. This is unusual, she said slowly. Most companies would never agree to a provision that could result in losing patent rights they've acquired. The threshold is very specific: termination without cause before FDA approval, with severance below 6 months of salary plus benefits. Is it enforceable? I pressed. If the conditions are met, yes, it should be, Patricia confirmed. It's unambiguous language in a contract both parties signed. The question is whether they'd actually trigger it, which seems unlikely. Why would they terminate you before the product launches and pay you less than the threshold severance? It would be shooting themselves in the foot. Unless they didn't understand the clause's implications, I thought. Or unless they were arrogant enough to believe they could contest it later if challenged. I thanked Patricia for her analysis, paid her consultation fee that represented 2 weeks of my salary, and returned to my documentation work with a new perspective on my situation. The employment limbo continued for another month. I completed the technical documentation Derek had assigned, delivered it to his office, and waited for new assignments that never came. I'd arrive at work each morning to an office that felt increasingly empty as former colleagues departed. My days consisted of reviewing old research files, updating personal copies of my work from my own records, and watching the clock until I could leave without seeming to abandon my responsibilities. The isolation was psychologically brutal. I'd gone from leading a dynamic research team, collaborating daily with brilliant colleagues, presenting at conferences, and advancing work I believed would save lives, to sitting alone in an office with nothing meaningful to do. Several times I considered resigning, but Patricia Eng's advice echoed in my mind: don't quit. Make them fire you if that's their intention. You'll have more options that way. The termination came on a Tuesday morning in late October, delivered via the impersonal medium that had become Derek's preferred communication method, a Zoom call scheduled with 15 minutes notice. When I joined the video conference, Derek was visible in what looked like his home office, dressed casually and clearly multitasking based on his periodic glances at something off-screen. "Dr. Torres, thanks for joining," he began without preamble. "I'll keep this brief since I have another call shortly. Titan Healthcare has completed its evaluation of staffing requirements for the integrated organization, and unfortunately your position has been eliminated as redundant with existing roles in our New Jersey research facility." The words were expected, but hearing them still felt like a physical blow. "I see," I managed, keeping my voice steady. "What's the timeline?" "Your employment will be terminated effective immediately," Derek continued, still with that detached corporate tone. "HR will send you information about final paycheck, benefits termination, and return of company property. We appreciate your contributions during the transition period." "What about my contractual equity and milestone bonuses?" I asked directly. Derek's expression tightened slightly with irritation at the question. "Given that you're no longer with the company and won't be involved in the product's development or launch, those provisions are not applicable," he stated. "However, Titan is offering a severance package of 3 months of salary as a gesture of goodwill for your service." 3 months of salary. I did the rapid calculation. My annual salary was $78,000, so 3 months came to $19,500 before taxes. After taxes, maybe $14,000. "The standard severance for my position level should be 6 months plus benefits," I pointed out, citing the threshold from my contract's reversion clause without mentioning it specifically. Standard severance policies apply to employees terminated without cause during normal operations, Derek replied with the careful wording of someone who'd been coached by legal. "Your position was eliminated due to organizational restructuring following an acquisition, which falls under different guidelines. The 3-month severance offer is actually quite generous given the circumstances." Generous. 3 months of salary for 6 years of work that had generated technology valued in the tens of millions for the acquisition. "I'd like to review this with legal counsel before accepting any severance terms," I said carefully. Derek's expression hardened further. "That's certainly your right," he said coolly. "However, the severance offer is contingent on signing a release agreement within 10 days. If you decline or fail to respond within that timeframe, there will be no severance payment at all." The threat was clear: take what we're offering quickly and without legal review, or get nothing. It was a common corporate tactic, using artificial time pressure to prevent employees from fully understanding their rights. "I'll expect the formal offer and release agreement by end of business today," I said. "HR will send everything," Derek confirmed, then added with obvious dismissal, "Is there anything else?" I thought about all the things I wanted to say. About the years of work he was casually discarding. About the patients who would benefit from research I'd sacrificed everything to develop. About the arrogance of a 28-year-old with no scientific credentials presiding over the dismantling of research he couldn't begin to understand. But none of those things would change the power dynamics of this moment. "No, nothing else," I said simply and disconnected from the call. The formal termination documents arrived that afternoon via email. The severance offer was exactly as Derek had described: 3 months of base salary, totaling $19,500, in exchange for signing a release that waived all claims against Meditech Solutions, Titan Healthcare, and related entities. The release language was comprehensive, covering everything from discrimination claims to intellectual property disputes to contractual obligations. I forwarded everything to Patricia and within an hour. She reviewed the documents and called me that evening. "This is exactly what I expected," she said. "They're offering you less than the contractual threshold, requiring you to waive all claims, and putting time pressure on the decision. If I don't sign, I get nothing, I pointed out. Correct, but if you do sign, you waive your right to enforce any contractual provisions including the patent reversion clause, Patricia explained. You need to decide which path you want to take. I stayed up most of that night, reviewing my employment contract for what felt like the 100th time, focusing on section 14.7 that contained the patent reversion language. The provision was unambiguous: if employment was terminated without cause before FDA approval, and if severance was below 6 months of salary plus benefits, all patent rights would revert to me. Titan would retain a non-exclusive license, but I would regain primary ownership. The calculation wasn't simple. If I signed the release and accepted the $19,500 severance, I'd have immediate money but no rights to the technology I'd developed. If I refused to sign, I'd get no severance payment but could potentially claim patent reversion. However, claiming those rights would certainly trigger legal battles with Titan Healthcare, a corporation with effectively unlimited legal resources compared to my non-existent ones. Patricia had been clear about the likely trajectory of such a battle. They'll argue that the reversion clause doesn't apply post-acquisition, or that your termination was for cause based on some technicality, or that the patent rights were modified by the acquisition agreement in ways that supersede your employment contract, she'd explained. You'd be fighting not just about contract interpretation but about corporate transaction law. It could take years and cost hundreds of thousands in legal fees. But there was another consideration that Patricia couldn't factor into her legal analysis: the principle of the thing. I had developed this technology over years of work that began long before Meditech existed in my life. I had brought it to them as a gift, trusting their stated mission to bring life-saving diagnostics to patients. They had extracted maximum value from my contribution while systematically eliminating every benefit they'd promised me in return. If I signed that release agreement and walked away with $19,500, I would be endorsing their right to do this. I would be validating the system that allowed mediocre men with family connections to profit from brilliant women's work while offering them scraps. More personally, I would be abandoning any claim to the technology that represented my grandmother's legacy and my life's purpose. I made my decision in the early hours of that morning, sitting at my kitchen table with my employment contract, the severance offer, and a legal pad where I'd been working through the implications. I would not sign the release agreement. I would accept no severance payment. I would invoke the patent reversion clause and claim my intellectual property rights, regardless of the legal battles that might follow. Patricia tried to talk me out of it when I called her the next morning. Emma, I understand the emotional appeal of fighting this, but practically speaking, you're looking at a legal war you can't afford and probably can't win, she cautioned. Titan will bury you in motions and discovery costs. They'll drag it out for years knowing you'll run out of money long before they do. I understand the risks, I said. But I didn't spend 6 years developing this technology to have it stolen by corporate restructuring and legal manipulation. If there's any chance of prevailing, I have to try. Any chance is optimistic, Patricia warned. You're talking about maybe a 20% probability of success, and that's generous. 20%. Not great odds, but not impossible either. I developed a diagnostic tool with 91% accuracy starting from a research idea that most people said couldn't be done. I'd overcome longer odds before. I need you to draft a letter to Titan Healthcare invoking the patent reversion clause and asserting my rights to the intellectual property, I told Patricia. If you're not comfortable representing me in this, I understand, but I need the letter drafted properly. Patricia sighed, a sound that conveyed both exasperation and reluctant respect. I'll draft the letter, she said. But Emma, you need to prepare yourself for a very difficult fight. They're not going to simply hand over patent rights worth tens of millions because of a contract clause. This is going to get ugly. The letter went out 3 days later via certified mail and email, formally notifying Titan Healthcare that I was declining the severance offer and invoking Section 14.7 of my employment agreement. Per that provision, the letter stated, my termination without cause with severance below the contractual threshold triggered automatic reversion of all patent rights related to my cancer detection algorithm. I demanded immediate acknowledgement of this reversion and requested that Titan cease representing the technology as their proprietary property. Titan's response came within 48 hours, not from their HR department but from their associate general counsel, a woman named Michelle Bradford, whose signature appeared on letterhead listing her credentials and multiple bar admissions in a clear show of legal firepower. The letter was masterfully composed to seem reasonable while fundamentally denying every claim I'd made. Ms. Bradford acknowledged receipt of my letter and expressed appreciation for my contributions during my employment. However, she continued, I appeared to have misunderstood both the intellectual property provisions in my employment contract and the effects of Titan's acquisition of Meditech Solutions. The patent rights I referenced had been transferred to Meditech upon my initial employment and subsequently became Titan's property through the acquisition. The reversion clause I cited was not applicable in the context of corporate acquisitions and organizational restructuring. Furthermore, the letter noted, my termination was not without cause but rather resulted from legitimate business restructuring that eliminated redundant positions. The severance offer, which I had declined, had been made as a courtesy despite the company having no obligation to provide any severance for restructuring-based terminations. Finally, Ms. Bradford stated that any further communications regarding intellectual property claims should be directed to her office, and any public statements I might make misrepresenting Titan's proprietary technology could subject me to legal action for defamation and tortious interference with business relationships. The letter was simultaneously infuriating and frightening. Infuriating because it so blatantly misrepresented both the facts and the clear language of my employment contract. Frightening because it came from a major corporation's legal department making barely veiled threats about consequences if I continued pressing my claims. I forwarded the letter to Patricia, who called me within an hour. This is a standard intimidation response, she explained. They're trying to scare you into dropping the claim by flexing their legal resources and making threats. However, they're also revealing something important. They're not completely confident in their position. How do you figure that? I asked. If they were certain the reversion clause didn't apply, they'd simply ignore your letter or send a brief dismissal, Patricia explained. Instead, they've engaged substantively and made multiple arguments. That suggests they're concerned that the clause might be enforceable and they're trying to establish alternative defenses. The corporate acquisition argument, the restructuring versus termination without cause distinction, these are backup positions they're preserving. This analysis provided some encouragement, though it didn't change the fundamental challenge. I was in a legal battle against a corporation with resources I couldn't match. What's our next move? I asked. We can respond to their letter pointing out the flaws in their arguments and reasserting your claim, Patricia said. But honestly, Emma, letters back and forth won't resolve this. If you want to seriously pursue your patent rights, you'll need to file a lawsuit. That means litigation costs, discovery, depositions, potential trial. We're talking a minimum of $50,000 in legal fees, possibly much more depending on how aggressively they fight it. $50,000. I had maybe $30,000 in savings, accumulated over years of living frugally. Even borrowing against that and taking on debt, I couldn't fund a prolonged legal battle. The impossibility of the situation settled over me like a weight. I had legitimate contractual rights that were being violated, but the legal system required resources I didn't have to enforce those rights. I spent the next week in a fog of depression and indecision. I'd update my resume half-heartedly, scroll through job postings for research positions, and close my laptop without applying to anything. The thought of starting over at another company, being another junior researcher working on someone else's priorities, felt unbearable. But continuing to fight Titan without resources seemed equally futile. My brother Carlos called during this period, one of his regular check-ins that had become more frequent since my job loss. I'd been trying to maintain an upbeat tone during our conversations, not wanting to worry him, but this time I couldn't muster the energy for false optimism. Emma, you sound terrible, he said bluntly after a few minutes of stilted conversation. What's really going on? I broke down and told him everything. The termination, the severance offer, the patent reversion clause, Titan's refusal to honor it, the legal costs I couldn't afford, the feeling of having my life's work stolen by corporate manipulation. Carlos listened without interrupting, and when I finished, he was quiet for a long moment. How much would you need to actually fight this? He finally asked. I explained Patricia's estimate of $50,000 minimum for litigation costs. But that's just to get started, I added. If it goes to trial or they drag it out with extensive discovery, costs could easily exceed $100,000. It's not realistic, Carlos. I can't afford it. What if you could? He pressed. If money wasn't the limiting factor, do you believe you have a legitimate claim to those patent rights? Yes, I said without hesitation. The contract language is clear. They're trying to ignore it because they think I can't afford to fight, but legally, I should own those rights. Then we fight, Carlos declared. I've been working in business finance for 6 years now, living well below my means and investing aggressively. I've got about $75,000 in liquid savings. It's yours for this battle. I was speechless. Carlos and I were close, but this level of financial support was beyond anything I'd expected. I can't take your savings, I finally managed. If we lose, you'd lose everything you've worked for. And if we don't fight, you lose everything you've worked for, which represents a hell of a lot more than my savings account, Carlos countered. Emma, you've dedicated your entire adult life to developing technology that saves lives. Some corporate nephew isn't going to steal that because you couldn't afford lawyers. We're doing this. His conviction was overwhelming and exactly what I needed to hear in that moment of despair. With Carlos's financial backing, suddenly the impossible became merely difficult. I called Patricia the next day and told her we were moving forward with litigation. The lawsuit we filed against Titan Healthcare Corporation was straightforward in its core claim but complex in its implications. Patricia drafted a complaint asserting that my employment termination without cause, combined with severance payment below the contractual threshold, had automatically triggered the patent reversion clause in my original Meditech employment agreement. We sought declaratory judgment confirming my ownership of the cancer detection algorithm patents, along with an injunction preventing Titan from using the technology without proper licensing agreements. Titan's response came exactly as Patricia predicted, a motion to dismiss arguing that the reversion clause was invalidated by the corporate acquisition, that my termination was for legitimate business reasons rather than without cause, and that even if the clause technically applied, enforcing it would constitute unjust enrichment since Meditech had funded the technology's development beyond my initial research. Their legal team, led by Michelle Bradford and 2 additional attorneys whose names appeared on every filing, clearly intended to bury us in procedural challenges. The first 6 months of litigation were grinding and expensive. Discovery demands required me to produce every email, every research note, every document related to my work at Meditech. I spent weekends in Patricia's office reviewing thousands of pages, flagging relevant materials, and preparing responses to interrogatories that asked increasingly granular questions about my research methodology and timeline. Titan's strategy seemed designed to exhaust both my financial resources and my patience through sheer volume of legal work. Carlos's savings depleted faster than we'd anticipated. Patricia billed fairly and efficiently, but litigation simply consumed money at an astonishing rate. Court filing fees, deposition transcripts, expert witness consultations, document review costs, everything added up relentlessly. By month 8, we'd burned through $62,000, and the case hadn't even reached the summary judgment phase yet. I'd found part-time work as a research consultant for a small biotech startup, enough to cover my living expenses but nowhere near enough to fund ongoing litigation. Carlos took a second job doing financial consulting on weekends to replenish the legal fund. The sacrifice he was making for my battle weighed on me constantly, but he refused to discuss stopping. The breakthrough came from an unexpected source during a routine deposition. Titan had insisted on deposing Richard Callahan, my former CEO, as part of their effort to establish that Meditech had substantially developed my initial research beyond what I'd brought to the company. Richard, now retired and apparently unconcerned with protecting his nephew's interests, was remarkably candid under oath. When asked about the patent reversion clause in my employment contract, Richard acknowledged that he'd personally approved that provision as an unusual accommodation to attract me to Meditech. Patricia, conducting the deposition, pressed him on why he'd agreed to such favorable terms for an employee. Dr. Torres brought us fully formed intellectual property with provisional patent protection already filed, Richard testified. Without her and her algorithm, we had nothing in the cancer diagnostic space. The reversion clause was protection for her in case we failed to develop the technology properly or terminated her before she could realize the benefits we'd promised. It seemed fair at the time, and frankly, I never imagined we'd be stupid enough to actually trigger it. That last phrase, captured in the deposition transcript, became crucial to our case. It established that the reversion clause was intentional, negotiated in recognition of my contribution, and designed to protect exactly the situation that had occurred. Patricia immediately filed a motion for summary judgment, arguing that Titan's own witness had confirmed the clause's validity and purpose. Titan fought the summary judgment motion aggressively, but their arguments had grown noticeably weaker. The corporate acquisition defense was undermined by contract law establishing that asset purchases generally don't invalidate specific contractual provisions unless explicitly addressed in the acquisition agreement. Their restructuring versus termination without cause argument fell apart under scrutiny of the employment contract's plain language, which didn't distinguish between different reasons for termination. The hearing on our summary judgment motion took place on a cold February morning 14 months after we'd filed the lawsuit. I sat in the courtroom gallery while Patricia presented our arguments to Judge Sandra Morrison, a former intellectual property litigator who had a reputation for cutting through corporate legal maneuvering. Judge Morrison listened to both sides, asked pointed questions that suggested she'd read the briefs carefully, and took the matter under advisement. 4 weeks later, her written decision arrived, summary judgment granted in part. The court found that the patent reversion clause was valid and enforceable, that its conditions had been met by my termination with below-threshold severance, and that Titan's acquisition of Meditech did not invalidate the contractual provision. Patent rights to my cancer detection algorithm were declared reverted to me as of my termination date. However, the judge also ruled that Titan retained the non-exclusive license specified in the original contract, allowing them to continue development but preventing them from claiming exclusive ownership. This was actually the optimal outcome from my perspective. I regained control of my intellectual property while Titan could still bring the technology to market, meaning patients would ultimately benefit. The immediate effect was transformative. Suddenly, I owned patents to technology that multiple companies had expressed interest in licensing. Titan, no longer able to claim exclusive rights, had to negotiate with me if they wanted to continue development. Within weeks, I had licensing inquiries from 3 major diagnostics companies who'd been monitoring the technology but couldn't compete while Titan claimed exclusive ownership. The licensing agreements I ultimately negotiated generated substantial revenue. Titan paid $2.3 million for an expanded non-exclusive license that allowed them to complete FDA approval and commercial launch. 2 other companies paid licensing fees totaling $1.8 million for rights to develop complementary applications of the algorithm. I established my own research foundation to continue advancing early cancer detection technologies, hiring back several members of my original Meditech team including Jennifer Liu and Akash Patel. Carlos refused to accept any return on his investment beyond the $75,000 he'd initially provided. "You would have done the same for me," he said simply when I tried to give him a substantial percentage of the licensing revenue. Besides, watching Derek Callahan's face when the judgment came down was payment enough. Apparently, word had spread through industry circles about the case, and Derek's reputation had suffered considerably from the revelation that he'd terminated an employee without understanding the contractual implications. The cancer detection technology received FDA approval 18 months after the court judgment, with my foundation and Titan's development team collaborating on final validation studies. The diagnostic tool launched commercially under the name EarlyMark, and within the first year of availability, it detected early-stage cancers in over 3,000 patients who would likely have been diagnosed too late under previous screening methods. I think about my grandmother often when I review EarlyMark's patient outcome data. She never got her 85% survival rate, but thousands of other people's grandmothers now have that chance because of technology that almost became another corporate casualty. The $3,800 severance check that Derek Callahan assumed would close this chapter of my life instead became the mechanism that returned my life's work to my control. Sometimes people ask if I regret not just accepting the severance and moving on to avoid the legal battle. The answer is always no. Fighting for what was rightfully mine wasn't just about patents or money. It was about refusing to accept a system where people like Derek Callahan could casually discard people like me, secure in the assumption that we lacked resources to challenge their decisions. It was about honoring the years of sacrifice that went into developing something meaningful. And ultimately, it was about ensuring that my grandmother's legacy lived on in technology that would spare other families the loss we experienced. The patent reversion clause that I almost overlooked when signing my employment contract turned out to be the most important negotiation of my professional life. It protected me when I was most vulnerable and provided the legal foundation to reclaim what corporate restructuring had tried to take. For anyone entering employment agreements involving intellectual property, that's the lesson I share. Read every clause, understand every provision, and never underestimate the importance of protecting your contributions in writing. The details buried in subsection 14.7 changed everything. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out.